Good morning, Your Honors. May it please the Court. My name is Diba, representing the appellant ALSJ Inc. on this appeal. This Court should reverse the trial court's decision by finding that the trial court incorrectly rescinded the mortgage documents and awarded attorney fees to the appellee. The trial court decision is incorrect for three reasons. First, the Mortgage Fraud Act does not apply because ALSJ is not a distressed property consultant under the Act. Two, the appellee is not entitled to relief under the Consumer Fraud Act. And three, even if the court finds that the appellee is entitled to relief, this court should find that the trial court abuses discretion by awarding attorney fees to the appellee. First, the Mortgage Fraud Act does not apply because ALSJ is not a distressed property consultant under the Act. The Mortgage Fraud Act defines a distressed property consultant in relevant part as any person who directly or indirectly, for compensation from the owner, stops or postpones the foreclosure, sale, or loss of the home due to non-payment of taxes, assists the owner in foreclosure loan default in obtaining loan or advance of funds, or saving the owner's residence from foreclosure or loss due to non-payment of taxes. ALSJ does not challenge the trial court's interpretation of the plain language of the Mortgage Fraud Act. Rather, the facts here clearly show that the Mortgage Fraud Act does not apply. Here, the manifest weight of the evidence favors ALSJ. Here, ALSJ was unaware that it issued the loan to appellee for the preservation of a distressed home. Rather, it believed that the loan was for commercial purposes, as evidenced by appellee's signed affidavit, which provided that the loan was for commercial purposes, and also provided that the appellee did not reside in the subject property, but rather an apartment in Lisle, Illinois. Lastly, the third parties involved in this case acted independently from ALSJ when they secured fees for themselves in connection of the loan. Second, the appellee is not entitled to relief under the Consumer Fraud Act. Under the Mortgage Fraud Act, an injured party may obtain relief under the Consumer Fraud Act, which allows for any relief that the court deems proper. As pointed out by this court in Steinberg v. Chicago Medical School, the main purpose of the Consumer Fraud Act is to protect consumers. In Brown v. Rail, this court defined consumers as those who contract for or purchases merchandise not for resale or in the ordinary course of his or her trade or business, but for the use of household. Here, again, the affidavit signed by the appellee to obtain the loan provided that the loan was intended for commercial purposes, and also provided that her main place of residence was different from the subject property and was located in Lisle, Illinois. Lastly, even if this court finds that the appellee is entitled to relief under the Consumer Fraud Act, this court should find that the trial court abuses discretion in awarding attorney fees. This is because the trial court already rescinded the mortgage note and the trustee, which serves to mitigate damages against an award for fees. Furthermore, the appellant did not act in bad faith. And for the foregoing reasons, this court should reverse the trial court's decision. Thank you.